Are you facing foreclosure and considering just walking away from the property? I'd like to explain to you why that could be the worst approach to dealing with a foreclosure and what you should do instead. Hi, I'm Jim Keaveney of Keaveney Legal Group. We are a New Jersey and Pennsylvania-based law firm that focuses on foreclosure defense. Every day we hear cases about an owner who walked away from a property that was going into foreclosure only to get a nasty surprise at the end of the case. Why? Well, the most common reason is the imposition of what is known as a deficiency judgment. When a house is foreclosed and sold at auction, the lender is entitled to a judgment against the borrower for the difference between the loan amount and how much the house sells for at an auction. This is known as a deficiency judgment. There are a number of ways to avoid it, but if one just gives up and walks away from the property, they might find themselves having to pay tens of thousands of dollars for a property they no longer get to enjoy. Speaking of which, another downside of walking away is the liability you could face for the vacant property. It can take months or even years for a foreclosure case to work its way through the courts. If you simply abandon the house, you remain liable for everything that happens in the property until the title transfers. So if someone decides to squat there, you could be liable to them for any injuries they suffer while on the property. If the house catches on fire after you move out, you could be liable not only to the neighbors if their properties are damaged, but to the lender for allowing the property value to diminish. In some instances, you may even be required by the city or a homeowners association to rebuild the house. Of course, aside from all the liability you could face if you simply walk away, there is the fact that with little effort, you may be able to save your home. Today, there are many options for borrowers to reduce their payments, obtain modifications, even get assistance making their mortgage payments. All of these options can help you keep your home, avoid the damage to your credit score foreclosure will cause, and prevent undue liability for walking away from the house. If you do not want to take advantage of those programs, do not qualify, or simply want to move, you could take advantage of other programs designed to facilitate a short sale. In the past, when making a short sale, the borrower could remain on the hook for the deficiency between the sale price and the amount owed. But new government programs have eliminated that liability in some cases. You should contact an attorney and make sure you qualify before trying to sell your house in a short sale. Alternatively, if you are not able to find a buyer or not inclined to spend the time and effort needed to make a short sale happen, you could enter into an agreement with the lender where you simply give back title to the property rather than making them file a lawsuit to foreclose. This is what's known as a deed in lieu of foreclosure. Just as with short sales, new government programs have made it possible to obtain a deed in lieu without facing the possibility of a deficiency. As a result, there are many options for homeowners today that are much better choices than simply walking away from a property. Of course, every situation is unique. You should contact a qualified, experienced attorney for advice on which approach would be best for you. Keaveney Legal Group is dedicated to helping those deciding how best to handle their foreclosure and pre-foreclosure property. We deal with questions like the ones we just discussed every day, and we would be happy to counsel you to the best course of action that would achieve your goals. We would love to speak with you about your case. You can email me at jim@keaveneylegalgroup.com or give us a call at 1-800-219-0939. I'm Jim Keaveney. Thanks for watching.